long does it go?
Live.
It's
Okay.
an hour.
About an hour.
We
And
sometimes, if there's lots of,
we
oh,
are
sorry,
live.
we're live.
Kate,
Sorry.
you're talking over me when we're going live.
Ah,
It is Tuesday, July 14th, 2020, the 110th day of In Lieu of Fun. You know, every morning I do a tweet where I tweet the number of days until Election Day and the number of days until Inauguration Day, and they are declining. And the number of days of In Lieu of Fun is rising. And I believe, I'm not sure, but I think tomorrow or the next day is the day they meet. They actually will never meet because they're In Lieu of Fun will exceed the days till Election Day. They'll be off by one, but I think it's tomorrow or the next day is the day they pass each other. So we will have had more days of In Lieu of Fun than we have days until the election. It may be a couple of days from now. Anyway, that is not why you're here to chat. You are here because it's McGirt Day. And you have heard a lot on this show about my excitement about this case, which brings together so many fascinating threads of American law and history. And so I asked Ian Gershengorn, who argued the case before the Supreme Court and won it, to come on and have a chat with us about it. And so Ian is, I'm not sure quite how to introduce Ian. Ian was the Deputy Solicitor General. He is the head of the appellate practice at Jenner and Block. He's, one of those appellate law superstar types. And he had the McGirt case. So let's start by telling the story of how you got involved in this case, because you weirdly don't represent, at least formally, either the tribes or the government of Oklahoma. You represent some guy named McGirt. So, tell us the story of how you got involved in this case.
Okay, it's a long story, so settle back. First, thanks to Ben and Kate for having me on. It's I've long admired the work that Ben has been involved in, and I've just met Kate, but this is really terrific. So thank you for having me on. So my involvement in McGirt actually started with a case from last term called Sharp v. Murphy, which involved a Native American named Patrick Murphy, who had been convicted of capital murder in Oklahoma. And he had brought a federal habeas challenging his state murder conviction on the ground that it had been committed within the historic boundaries of the Creek Reservation. He was represented at that time by a fantastic federal defender named Patty Palmer Gezzi, who is knowledgeable in both criminal law and Indian law. And he pursued that claim in federal court. So the core of the claim was this. If he had committed the crime within the boundaries of a live current Indian reservation, then he couldn't be prosecuted in state court. He could only be prosecuted in federal court. And that was particularly important for Mr. Murphy because he was on death row in state court in Oklahoma, and there would be no federal death penalty for murder, even if the state chose to retry, even if the federal government chose to retry him. So he brought his claim in federal court. He lost at the district court level, but the 10th Circuit granted his habeas petition and said, yes, Mr. Murphy, you are correct. The Creek Indian Reservation survives. We can talk about the reasons for that later as we go through the story. At that point, the state of Oklahoma sought cert, and the Solicitor General's office filed a brief on behalf of the United States, uninvited at the cert stage, which is very unusual, and the Supreme Court granted cert. So Patty Gezzi was looking for Supreme Court counsel and reached out to me to help with the case in the Supreme Court. So we were co-counsel, and we worked together on a brief for Mr. Murphy. The distinctive thing about Mr. Murphy's case for these purposes was that Justice Gorsuch was recused from his case. Justice Gorsuch had been involved in a 10th Circuit panel on an earlier version of Mr. Murphy's case, actually having nothing to do with Indian reservations, but that was enough to recuse him. And so there were only 8 justices on the court. So I argued Mr. Murphy's case last term, and we kept waiting for a decision and waiting for a decision. And it got to the last day of the term, and the court was handing down opinions. And as you know, the court releases opinions in reverse order of seniority. And so all the justices had gone, and then it came to the Chief Justice. And there were only 3 opinions left in the term at that point. It was census, gerrymandering, and Murphy. And so the Chief Justice announced the gerrymandering case, and then we were waiting and waiting. And then he announced the census case, and we were thinking, this can't be that he's about to announce Murphy after saying, here's census and gerrymandering, now something that you really care about, Murphy. And so instead, what happened was the chief announced that the Murphy case would be re-argued in this term, the next term, which was this one that just happened. And so, we prepared for our re-argument, or started to think about it, and then the court didn't schedule it for October, and it didn't schedule it for November, and we started to think that's a little odd, because here was a case that was fully briefed and set for re-argument. And so we began to think that maybe the court was looking for a different case to raise this same issue. One that Justice Gorsuch wouldn't be recused from. So we started scanning the court's docket and looked at cases that were brought against Oklahoma involving Indians. And we focused on Mr. McGirt's case as a case which might meet the court's requirements. And by that I meant it is an Indian case involving the Creek Indian Reservation, and therefore set up the exact same issue that was in Murphy. So I called up Mr. McGirt in prison and said, if your case gets granted, would you like free Supreme Court counsel? And Mr. McGirt at that point was unrepresented. He had done a pro se state post-conviction hearing. He had done a pro se appeal to the Oklahoma Court of Criminal Appeals, and he had done a pro se cert petition. And he said, I would be thrilled to have free representation. Thank you. And so then when the court indeed granted, I called up Mr. McGirt and said, they've granted your case, and I'd be happy to represent you. We immediately notified the court that Mr. McGirt was now represented, and then went from there. So that's how I got involved in the McGirt case for the first time.
So if you were, but when I read listened to the arguments in McGirt, they're essentially interchangeable with the arguments in Murphy. I mean, the only difference that is really discernible is the brief account of the facts, the factual history. The issue is the same. Serious crime takes place on the territory of the historic reservation, which, if you count all 5 of the historic reservations, it's literally half the state of Oklahoma, including Tulsa. And the state says those reservations ceased to exist when Oklahoma was incorporated as a state. The tribes say Congress never formally abrogated their sovereignty, therefore the reservations persist. Is there any material difference between the McGirt case and the predecessor Murphy case?
So not on the facts and the core legal issue. They're just as you've described. I mean, the key issue was the Creek Reservation disestablished around Oklahoma statehood? In the second case, in McGirt, Oklahoma raised 2 other arguments that it hadn't raised in the Murphy case, and one of those in particular was important, I think, for sort of how the case evolved and the different ways the courts could have gone. So there were 2 other arguments. One of them was raised by the Solicitor General in Murphy, but Oklahoma didn't adopt, and then it adopted it in McGirt. And that was the argument that even if there was a reservation, and even if it persisted through today, that doesn't matter for Mr. McGirt or Mr. Murphy, because Congress had transferred criminal jurisdiction to the state back in around Oklahoma statehood. So if the court had adopted that theory, my clients would have lost even if the Indian reservation won, and we can talk about that. The other argument that Oklahoma raised in McGirt, which had not been raised in Murphy, was that the Creek never had a reservation at all, that all they had was some other thing called a dependent Indian community, and that there never was a reservation in the first place. That was a new argument in McGirt. That was an argument that the Solicitor General's office did not join, and it was one that the court made quick work of. But so to answer your question directly, the core legal question was the same, but Oklahoma did make two additional arguments that it hadn't raised in Murphy that we had to deal with along the way, and that the court dealt with, that Justice Gorsuch dealt with, in his opinion, in McGirt.
And I suppose the other big difference was that your opposing counsel at argument was, in the first case, was Lisa Blatt, who is, herself a celebrated appellate advocate, and in the second case was the Oklahoma Solicitor General's office. Is that right?
That's right. I mean, Oklahoma, so it's right on at everything you've said. Lisa is a fantastic advocate, one of the best in the country, and she had argued for Oklahoma while she was at the time at Arnold and Porter. And so she argued that case. She argued Murphy. She has subsequently moved, of course, to Williams and Connolly. The state remained with Arnold and Porter, and then the Solicitor General of Oklahoma argued the second case, McGirt. In each case, though, Oklahoma was the party. They just had gotten private counsel to help them along the way. The other advocate each time, all the other advocates were the same. So Ed Needler argued for the Solicitor General's office in both Murphy and in McGirt. Riaz Kanji, a longtime friend of mine, we've been working together for decades, represented the tribe, and he argued
him to join us today, but we couldn't make the timing work.
He's terrific. So he argued for the tribe both in Murphy and in McGirt, and then I argued for Murphy and for McGirt in both cases.
So let's talk about the substance of the case. So for a lot of Americans have a kind of dim sense of the Trail of Tears, but this is actually an active litigation that persisted till 2020. That is a direct consequence of the Trail of Tears, in the sense that the question is whether, when the tribes are removed from their historic homelands in the southeastern United States, I guess what's now Georgia and Alabama, at the time of the Jacksonian Indian removal policy, they are promised these lands in Oklahoma that they, after the incredibly deathly removal that leads them there, they have for the subsequent sort of 70 years before Oklahoma statehood causes them to be dispossessed of those lands as well. And this is a litigation about whether that second dispossession is valid. And so I guess my question is, how did we go this long without resolving this question?
So it's a good question, and part of it, I think, involves just the history of the treatment of Indian tribes, particularly around the turn of the century. So when we're talking Oklahoma statehood, we're talking, the Enabling Act in 1906 and statehood in 1907. And, in the wake of that, the tribes, particularly in Oklahoma, are being treated just appallingly. They are literally fighting for their lives. Part of that in Oklahoma has to do with the discovery of oil. And, basically what you had was a feeding frenzy, taking advantage of tribes. There's a terrific book called Killers of the Flower Moon, which details some of the treatment of some of the tribes around this period. And it literally is, assassination, murder, and things of that nature. And the tribes are fighting for their lives. Meanwhile, they're being overwhelmed by settlers. And so, it's almost a quaint notion to think that what should have happened is the tribe should have stood up and said, actually, you state court lack jurisdiction to prosecute me. I should be tried in federal court. They were literally fighting for their existence. And so part of that is a history developed in the immediate aftermath of statehood that almost rendered the reservation question, in a sense, academic. It just was the furthest thing in some ways from people's minds, which was not to say that the tribes doubted that they had a reservation. It's that they were fighting for their existence. So, and part of that was events on the ground. Part of that is a long history of shifting federal government policies towards Indians. Sometimes it's assimilationist, sometimes it's about tribal independence, sometimes it's eliminate the tribes, and that was a time where tribes were very much at risk of extinction in some ways. What's happened over the last starting in the 1930s, but moving in the last 5-6 decades is a restoration of the tribal sovereignty. And so some of these reservation issues are coming to the fore, not because all of a sudden the tribes believed for the first time that their treaty promises were still valid, but more because the tribes for the first time were in a position to actually have the power to try to enforce those treaty promises. And so I think that's sort of what happened over the first 50, 60 years. As to the question of, why is it just now getting to the court? These cases were kicking around in Oklahoma for many years, and, they take some time to work their way up. But that's kind of the history that explains the delay, I think.
Can I ask a quick question? Which is I spent a lot of time in the Flathead Reservation in Montana, and and as an attorney, and I was before law school, and then after law school, there, and dealing with kind of various kind of whenever I would be there would be kind of there was different presences of police forces and different types of, there was tribal police forces, and then there were there were state and local. What I'm kind of very interested in is also just how we talk about these tribal. So you say Indian, some people say Native American. You also say Native American. There's also First Nation or First Nation kind of ideas. I know this is a small detour from the McGirt conversation, which I want to kind of really delve into the legal stuff. But I'm very curious, just kind of what is the general sense about how you distinguish between those different terms that you use?
So I probably am, I may not be as sensitive as I need to be on that. I have used the term Indian and Native American somewhat interchangeably, and certainly we did during the briefing, and I think the court has, and I've seen it both ways. I mean, one of the interesting things about the point you've raised, a separate point, is on the policing itself. Policing is one of the issues that's, most, I think, near and dear to folks' hearts when they think about the McGirt case. And you're exactly right. On a reservation, the allocation of responsibility among tribal police forces and federal forces and the state police is, state police can be very complicated. One important point for this case is that in the real world, particularly in Oklahoma, that was largely theoretical, and it was a point that both we emphasized and the tribe, really emphasized a lot, because in the real world, there are a lot of agreements between the police forces that cross-deputize the various police forces, and so it matters less what the particular jurisdiction of a tribe might be in the abstract, because they've signed an agreement with Oklahoma, with Tulsa, with the U.S. Attorney's Office to cross-deputize so that all of the relevant law enforcement agencies have, for example, arrest authority throughout the historic boundaries of the reservation. And
they do ask you for your reservation card, though, if you get pulled over. They're like, you get special treatment if you're like a reservation member. It's like very interesting. Yeah. So.
Yeah, I mean, it does have jurisdictional consequences for where you would go, but, which court might have jurisdiction. But in terms of arrest authority and things like that, it's, those things are worked out in the ground. And we could talk about that more. But, one of the main tensions in the case was always between the plain language, which very much favored us, and this sort of fear of practical consequences, which Oklahoma was raising as the main argument on the other side. And much of our response was, look, in the real world, this gets worked out. This is not something, this boils down to scare tactics, essentially, that in the real world, these things all get worked out by agreement.
So let's talk about those in sequence, because...
But also, Ben, I would love to ask you how you came to be so fascinated by this case before we dig into into Ian's kind of stuff. I would love to know how you became so fascinated with this case a little bit, because you're super fascinated with it, and I love that, and I think it's great.
So I think the history of federal tribal relations is a really interesting subject in general. And I was sitting at dinner one day a few years ago, and my older kid asked me, so is half the state of Oklahoma really still part of Indian reservations? And I don't know where he dug this up, but I said something off the cuff, which is not, by the way, a crazy thing to say, which is there's a great principle of Indian law in the Supreme Court, which is that the Indians always lose. And even when they win, they lose, right? And I said something off the cuff like that, and then I thought I kind of owed it to the kid to have a little bit more of an informed view of the subject. And so I took a look at the underlying 10th Circuit opinion, and which is a striking document, because this is the 10th Circuit Court of Appeals, if I recall correctly, on the is that right, Ian?
No, the 10th Circuit was a three-judge panel, but then there was a serious en banc petition, and the author of the decision, Judge Tinkovich, concurred and wrote something at the en banc stage where he said, basically, the law is crystal clear, and we followed it, but it seems to us like a very odd result, and the Supreme Court may want to take a look at it. And so it was a panel decision that was denied en banc, but with an en banc concurrence by the judge, sort of suggesting that the Supreme Court should get involved.
And so I, looked at that and thought, gosh, for the 10th Circuit to say, number one, the law is crystal clear. Number two, it's a super weird result. And number three, flagging for cert over here, I thought was very striking. And so I kind of got interested in it at that stage. And then Rebecca Nagel, who is a Cherokee Nation journalist in Eastern Oklahoma, did I thought, quite wonderful podcast series on the case and the history behind the case, which is called This Land, which I thought was quite good, although had some elements that I wasn't crazy about. But I thought it was really very strong. And so I've just, it's kind of lurked in the back of my mind. And then the other factor that got me even more interested in it was in the original oral argument. I would say this even if Ian weren't here, just the quality of the advocacy in the oral arguments was like, wow, we gotta listen to this oral argument. And so, you had like Ian and Lisa Blatt squaring off, and and Niebler Kanji, and so it's a really great, just as at the advocacy level, the briefs were really terrific. The history was really well done. The arguments were super well presented. And so it's just a case that's kind of got everything. Plus, I would be remiss if I didn't add, it has a certain moral gravity. It's not every day that you really have a litigation over one that's really directly about one of the great crimes in American history. And
completely.
And
Ben.
so it's just this, it's at every level that a case can be interesting. It's really interesting, including that it stabs you in the heart. So Ian, let's talk about the merits of it. The technical issue at stake in this case is whether Congress did or did not exercise its uncontested power to disestablish the reservation when Oklahoma was created. And the weird background is that there's no real question that in functional terms, the government was the tribal governments were taken down, their authority over their land was taken, but Congress seems to have never dotted the I and crossed the T and actually passed a law that says you guys no longer exist. And so my question is, first of all, walk us through the legal argument on which you work. And then I'm interested for your reflections. Why did Congress not bother? Was it just that the tribes were so easy to walk over that you didn't actually have to do it?
So, it's an interesting question, Ben. I'm going to, as you'll hear in my answer, I'm going to take issue with a couple of things you said, because our whole position was that's not really right. So the way you've described it is, I think, the way the state thinks about it, which is that basically in all but name, Congress had eliminated it, and basically the tribe sort of discovered this gotcha argument. And from our perspective, that really couldn't have been further from the truth. And so let me sort of start and bring you up to walk you through at least how we saw the case. Mm-hmm. So the core theory is, of course, that once Congress creates an Indian reservation, only Congress can disestablish. So as you said, Congress has an undisputed power to break treaty promises, but only Congress can do it. It's not the kind of thing that a state can do just by pretending the treaty doesn't exist, and it's not the kind of thing that settlers on the ground could do by just ignoring treaty rights. That's not how we amend statutes. And, that's true across law, right? And so if Congress passes a statute, the executive branch interprets it a particular way, or the states do, we don't think, okay, they've amended the statute by just ignoring it. We think, no, they're acting illegally by ignoring the statute that Congress passed. And so we were arguing to the court, that's the same thing that happened. So, key to that, I think, is understanding why we thought this was not a gotcha and why it meant really substance. And there were two aspects to that. One of them was, the argument that the Congress had before it a clear way to disestablish the reservation. So the Creek Nation had sided with the South in the Civil War, and as a result, Congress, after the war, cut way back on the Creek Reservation. And when they did so, they put in language that clearly disestablished a chunk of the reservation. They said, we, the Creek, cede back to the United States that land. And that is the language that is like the classic how you disestablish. When Congress in the 1900s, right around the turn of the century, 1901 and just before that, was negotiating with the Creek, they sent out negotiators who sought language like that. Will you agree to cession? And the Creek said, no, we won't. We don't agree to cede our land. And at the time, Congress was under the impression that they couldn't unilaterally force the tribe to cede their land. And so rather than cession, they agreed to something called allotment. And allotment in Indian law is different from cession. What allotment means is you give up your title. It goes to people who can buy it, in this case settlers, but you don't give up your sovereignty over the land. It doesn't change the boundaries of the reservation. And so the first argument we made, which was important to the court, was that Congress knew how to disestablish. They could have used the word cession. They used the word cession in several statutes throughout the 1800s with respect to the Creek Reservation, and they affirmatively chose not to use that language here. They chose allotment. And so that was a deliberate congressional choice. The second key piece is that, and this goes to your suggestion that they had eliminated the tribal government. So in this 1901 statute, actually what Congress did was say, in 5 years, in 1906, the Creek government is eliminated, right? We're getting rid of the Creek government unless we say otherwise. So what happens then in 1906, right around the time of statehood, is that Congress passes a statute and says, actually, we've decided to preserve the Creek government. And so Congress then passed a statute that undid the elimination of the Creek government. And so that, again, was a time when if Congress had done nothing, as you said, sort of failed to act or failed to dot the I and cross the T, it just sat on its hands, the Creek government would have disappeared and the reservation would have been eliminated. Instead, Congress actually passed affirmative legislation to keep the tribal government intact. And we pointed that out to the court. We said, this is not a game of gotcha. This is not like, oh, Congress forgot to say the exact thing it was supposed to say. What Congress did was actually make two deliberate choices to preserve the Creek Reservation when it could have, by pure inaction, disestablished it. And so we thought for the court that actually that was quite important, that we were not, I know I'm repeating a little bit, but we were not arguing that we discovered some cute way to get around it. We really thought we were dealing with substance, where in this case, Congress had made deliberate choices that should be respected.
Right. So so that's an interesting clarification and correction. I didn't mean that Congress had sort of just neglected to do it. But what I've never understood in your presentation of the history, which I agree is clearly the one that is most consistent with the text, is what Congress thought it was doing. Because it's clearly trying to at some level, it's trying to create a state. It is trying to create a state. It's trying to greatly diminish the significance of these governments. So what do you think, if you go back to the congressional, I mean, let's be not textualist here for a moment and say, what was Congress's intent? What were they trying to do to the governments of the 5 tribes?
So I guess, to me, what Congress was trying to do was not so much to the governments of the 5 tribes, but what Congress was trying to do for settlers. And what Congress was trying to do was open up lands for settlers, and they did that. But there are a couple of key points, I think, that again sort of underlie this history and that make some of Oklahoma's arguments very ahistorical, which are important. The first is this notion that somehow Indian reservations are incompatible with statehood. So at the time Tennessee became a state, 3/4 of its land was an Indian reservation. When Arizona became a state, 47% of its land was an Indian reservation. And when South Dakota became a state, I forget the exact number, but it's around 20% of its land was an Indian reservation. And so this idea that you couldn't have an Indian reservation while you had a state just is not true. It's ahistorical, it's not accurate. And so I think part of the mindset was that there is nothing inconsistent with statehood with having an Indian reservation. The second piece is that the key thing that Congress definitely wanted to do was open land for settlers, and they did that. So the fee title to the land went to the largely white settlers who came onto the land. And so the tribe lost ownership of the land. But that was different from losing the ability to govern the land. And, you can think about that at its most elemental. Tulsa, of course, doesn't own most of Tulsa. In fact, it probably doesn't own any of Tulsa. But it governs all of Tulsa. And nobody thinks that's incompatible, right? You don't think, Tulsa has to own the land to govern it. It's perfectly okay to say private individuals own that land, yet the government of Tulsa and the government of Oklahoma exercise sovereignty. It's the same idea here, right? That the tribe didn't have to own the land in order to have some governance over it. The exact extent of sovereignty, of course, changed with statehood because now you had another sovereign in place. It wasn't just the United States and the tribe. It was the United States and Oklahoma and the tribe. But that is not inconsistent or incompatible with having sort of tribal government. And indeed, at the turn of the century, over the first, in the 1903, I think the case was, there were cases that involved tribal imposition of taxes on settlers in this new land. And what the court said, both the Eighth Circuit and ultimately the Supreme Court, said was, yes, the tribe still has authority to impose tax on these lands, even though they've been given to settlers. And so, tribal ownership is not the same as tribal sovereignty. The idea that you have a reservation with some tribal sovereignty is not inconsistent with statehood. And so, the whole jurisprudence that has arisen in this area is about the court trying to figure out which of two things did Congress do. Did, on the one hand, Congress disestablish the reservation and just eliminate tribal sovereignty? Or did, on the other hand, Congress open up the land to settlers, open it up for private sale, but leave the boundaries of the reservation intact, giving the tribe some sovereignty over the land? Again, the exact extent is, maybe debated in a particular case. But that's how these cases, and there have been, 6 to 10 of these over the last 5 or 6 decades, that's what the cases have asked. Which of these two things did Congress do? And the court over the years has said sometimes Congress has disestablished the reservation, and sometimes Congress didn't disestablish the reservation. It just opened up the land for sale. And so that, I think, is the important background as you think about these questions and you ask yourself, what did Congress do? If I could just make one more point, again, I apologize for going on a bit, but I love to talk about this stuff.
Great.
Is that what the court has said over and over, and this was really important for looking at the text, is that if you actually asked the individual senators and representatives at the time, do you think this reservation will exist in 20 years? Possibly to a person, possibly to a man, I guess, they would have said no, right? But that is exactly what Justice Gorsuch and the focus on text gets rid of, right? The question isn't what do you think might happen in 20 years, or what do you hope happens, and what kind of things might be good policy from your perspective. The question is, what's in the text that you enacted? And that is the core distinction in textualism. And it's definitely something that, as we brief the case for particularly in McGirt for Justice Gorsuch, but even for Murphy when we were hoping to get Justice Thomas, we spent a lot of time emphasizing that you don't try to figure out what would some senator have thought might be a good outcome. You want to figure out what is the actual text that those senators adopted. And the reason for that is because there are a lot of compromises that go in. As we dug into the legislative history, it turned out that Congress wasn't of one mind, that there were a lot of pro-tribal members who thought that reservations were really important and that respecting treaty promises was really important. And then there were a lot of people who thought this is insanity. All we care about is let's open this up for statehood. And so, like every other major piece of legislation, you find legislative history with both sides. And the ultimate legislation that led to the Enabling Act for Oklahoma and led to the Five Tribes Act, which dealt with some of the five tribes, both of those passed in 1906. They were compromises, and there were things that came in at the last minute that were pro-tribal and some things that were left in that were very anti-tribal. And I think, again, we tried to portray that to Justice Gorsuch and say, this is exactly why you look at the text, not the question of, what was Congress thinking, if that term even makes any sense. It doesn't matter what Congress was thinking, because Congress is a lot of individuals who may not have shared the same thought.
So I teach property and property law to God bless them. They have to get property law from me. I always tell them, I am the opposite of a property. There are two types of property law professors. There's the really cool, IP property law professors. And then there's these old, you're going to come in and teach them about dusting off deeds and researching boundary lines. But I do think that I teach in Macintosh, however you pronounce it, Johnson v. McIntosh. And I think that case is, I always teach that case as this case that is about basically, I show an Ezzy who is it? An Eddie Izzard clip of him being do you have a flag? And we just got here, and do you want to be a sovereign citizen? Do you have a flag? We're gonna take over your lands. You can't have this land. We live here. This is our place. And oh, well, do you have guns? Do you have a flag? We have a flag. And there's and then that establishes it all. But I do think what do you think about Macintosh after this? What do you think this is for property rights? Because as you said, Oklahoma doesn't own, the government of Oklahoma doesn't own Tulsa. Obviously it doesn't. It doesn't own the property, and it governs it. What does this mean for the tribal lands in terms of ownership and governance of those tribal lands? Does it make them more interrelated?
So a couple of things. I do think one of the critical points is the distinction between ownership and governance. The tribes, this is why, again, the sort of, I think, the almost fear-mongering that took place before the argument, and even some of the headlines after, we have given half of eastern Oklahoma to the Indians, right? That's not what happened, right? If you own property in Tulsa the day before the decision, you own that same property the day after the decision, right? It's you're now within the boundaries of a reservation, but your ownership hasn't changed, right? We did not give half of eastern Oklahoma to the Indians. What we recognized was that they have a reservation that includes, so far it's only the Creek, that includes the historic boundaries of the Creek Reservation and parts of Tulsa. But what comes with that is that the tribes have some measure of sovereignty over that land. And again, it's the same way that.
But those are the properties of property, which is use transfer, ability to exclude, all of these types of things. Of those, this kind of seems to just really hit on use. Right?
So I would say yes and no. It does affect use, but in the sense that there is now some tribal regulation. But the Supreme Court has cut way back on tribes' abilities, for example, to regulate non-Indians who own their land even within a reservation. And so this is why, again, Justice Breyer asked me at the first argument, if I woke up and I owned land in Tulsa and you told me the next morning I woke up and am now in an Indian reservation, how has my life changed? And I said to him, not very much, right? The main differences actually involve things like taxation, and those are important. The state's ability to tax Indians on the reservation is more limited, the flip side is the state's ability to regulate tribally owned businesses is more restricted. But the tribe actually has quite limited ability to regulate non-Indians who own their land on a reservation. And the state, conversely, maintains significant ability to regulate non-Indians on the land. And that's as a result of a whole series of cases in Indian law, which have cut way back on tribal regulation. So the case is important, and it's hugely important for reasons I could talk about to tribes in general. But it is not the case that all of a sudden, if you, Kate, owned a piece of land in Tulsa, all of a sudden you would be answering to the tribal government. It's just not the way Indian law has evolved over the years in the Supreme Court. And again, we pointed that out. The Solicitor General's brief in its discussion basically agreed with most of that the focus is on zoning and tax. And what happens in the real world in those issues is the tribe and the state and the federal government work it out. And there are agreements that deal with how do we tax. There are agreements that deal with how do we zone. And I expect that you will see a number of those in the next couple of months. And indeed, right after the argument, the Attorney General of Oklahoma issued a joint statement with a number of tribes that said, we have been negotiating with the tribes to come up with a framework for regulation, which we would submit to Congress. And I'm not involved in those. I don't represent the tribes, but I would expect that something like that will emerge and be passed that will iron out these last few wrinkles. But, again, just circling back to the core of your question, the core of your property bundle, your bundle of rights as a non-Indian, even on the reservation, probably hasn't changed very much.
Yeah,
okay,
that was what I was afraid you'd say.
So let's talk about then what the tribes really get out of this. If today part of Tulsa is in the Muskogee Creek Reservation, and yesterday it wasn't, and the practical impact is not very much, does that suggest that Indian sovereignty is overrated?
No, I think it's hugely important, and the case is huge. Both the sovereignty and the case are very important in a couple of different ways. First of all, the tribes do exercise authority, for example, like law enforcement authority throughout their reservation. That's critically important. The tribes would have some court jurisdiction. The Creek have a very well-functioning court system. That jurisdiction would also increase. So those kinds of things do matter. And I think it also candidly probably changes the negotiating structure, right? If you're negotiating a series of agreements, it matters a lot how the Supreme Court assigns the initial bundle of rights, and that certainly has happened over the years as the court has decided tax disputes. If it decides the tax dispute in the tribe's favor, they negotiate a better deal with the state, and if the tribe assigns the tax dispute if the court decides the tax dispute in the state's favor, the tribal deal is going to be worse. So, in the real world, this has important consequences. I think the broader significance of the case, though, is a real reinvigoration of tribal treaty rights. It is a significant sign by the court, both in this case and a case from a term or two ago called Cougar Den, where Justice Gorsuch again joined with the four more liberal justices, that the court is taking treaty rights seriously. And that's hugely important to tribes in general and hugely important to tribal identity and, and tribal history. These treaties are, you described some of the history in the Trail of Tears, and that, those historical events were ended up in treaties, and those treaties are very important to the tribes. And what the court has said, and what Justice Gorsuch has said, is we're taking the text of those treaties very seriously, and that's an important development in tribal law.
So one other area where, again, my knowledge of Indian law is not great, but it seems to me it's got to have some major implications, is land use, and not just zoning, but regulation of industrial land use. That if it's got to give the tribes a seat at the table regarding major land uses that a sovereign power would have something to say about it, from agricultural to industrial, and maybe less at the individual level, what you can do with your property as a non-tribes member in Tulsa. But if you're a corporate entity that's operating in eastern Oklahoma, maybe today you have to think about the tribe in a way that 2 weeks ago you did not.
So, that may be that the tribe may have a seat at the table. The jurisdictional rules can be complicated. Again, it depends a lot on the facts and circumstances. But I do think you're right to say that the tribe is likely to have, a seat at the table. And I would think that that's exactly what's happening now. That, again, I'm not involved in that. I don't represent the tribes here in Oklahoma. I represent individual defendants. But I would assume that there are conversations going on between the tribes and the state over exactly how to deal with regulatory questions, including regulations of private businesses. And, this has happened elsewhere. One of the things we talk about in our brief is that the city of Tacoma, Washington, is a big chunk in Indian reservation. And yet the Port of Tacoma has a lot of industry and a lot of trade, and things function pretty well. And what has happened there, of course, is there was an agreement which was eventually incorporated into a federal statute that allocated jurisdiction between the tribe and the state and the city. And I assume that a similar thing is likely to happen here. And certainly, I would say the statement of the Attorney General and the tribes in the wake of the decision suggests that something similar is going to happen here. And so, I do think that, I guess what I would say about the opinion is that it is an important opinion with real consequences, but it is not an existential opinion for the state and should not be overplayed. And I think both of those are true. And that's what we tried to say to the court. Like, yes, when you decide a case, court, it has real world consequences. But those consequences don't include some of the rhetoric that Oklahoma used, which is to say we're only half a state now. It's like 49 and a half states, and we've been, eviscerated in terms of our sovereignty. And all of that was never true and isn't true today.
Okay, so we have a bunch of questions from the audience, some of whom do not want to be brought in to ask it themselves, so I will just read. Question from Thomas. Considering that the history of the case goes back to the Removal Act, what does McGirt mean for the rest of Indian country as of 1830, i.e. all of the American West from Mississippi writ large, or more strictly speaking, the former Missouri Territory, if we're going by the boundaries of the Indian Intercourse Act? A bunch of people have posed a variant of this question, which is, how specific is this to the situation of Oklahoma, or to what extent does it, presage a revival of the idea that you gotta take, as you put it, take these treaties very seriously?
So I do think that it does pose. It is going to say we take these treaties very seriously. And to be clear, it's not so much not only McGirt, but the Cougar Den case that I mentioned was the interpretation of a Yakima treaty. And it goes back a few years before that. One of the cases that was foundational for our argument was a case called Parker, which involved a reservation in Nebraska, which the court also held had not been disestablished, even though the tribes had been absent from that land for 120 years. And so, I do think what you see in the last few years is a tendency of the court to take tribal rights and tribal treaties more seriously. Part of that is, I do think, a renewed emphasis on textualism. I think part of that, particularly for the latter two cases, is Justice Gorsuch, who I do think is somebody who takes tribal rights seriously, and he is in particular not likely to be swayed as much by sort of vague claims that the sky is falling. And so I do think that tribal rights are going to be taken more seriously. Do I think that this means that all land is going to be returned to the Indians, or some hint of that in the question. No, of course not. I think what's going to happen is the court is going to look at particular treaties and take those treaties seriously. Now, one of the questions it's going to ask is, did Congress, break that treaty promise? If Congress did, then, we sort of move on. But I think there will be things like hunting rights, fishing rights, right to travel was at issue in the Yakima case, and in some cases reservation boundaries that may be taken more seriously. Now, this particular case, as you know, Ben, from having followed it so closely, depended a lot on the particular history. I mean, we spent a lot of time looking at the history of the Creek Nation, the particular back and forth between Congress and others.
Really heavy on 1906.
Yep.
Yes, I mean, we looked at the period from 1890 to 1907. Exactly, right? From 1890 to 1907, we felt like we did a lot of looking at statutes and history and what was happening on the ground. We had an amicus brief from historians and scholars talking about what had happened to the Creek in that period. And so, I do think the opinion is, in some ways Creek specific and in some ways much broader than that.
All right, so we have a question from Mitchell, and then a follow-up question that I want to do them as a pair. So Mitchell writes, what stops Congress from now disestablishing the reservation? For example, for oil rights, do we think political pressure is enough to stop that? And then Genevieve, who is here, has responded with a question of her own, which I will let her pose.
Yes, just as a quick follow-up.
Oh, we can barely hear you. Can you turn up your mic volume?
You're very quiet.
Can you hear me now?
You're still very quiet.
But I can hear you.
Loud.
Okay.
That's perfect.
Okay, that's better.
All right.
That's great.
Just as a follow-up, the language mentioned in a treaty that was referenced in the opinion said that the U.S. would grant a fee simple to the Creek Nation, the entire territory area. And I kind of assumed then that change in ownership would not only require breaking that treaty, but also trigger a takings clause issue. And so I wanted to know if you thought that there was any way, both morally or financially, that the federal government could provide just compensation.
So the question of fee ownership is a very interesting one, and I see some of the comments. There were some comments that suggested that the tribes never owned the land after McIntosh v. Georgia. So that was not true with the Creek. What made the Creek reservations so distinctive, one of the things, was that they actually owned their land in fee simple. There were restrictions on that, but it was not solely a trust reservation, and that was not accidental. In the Indian Removal Act, the tribes, remember at this time, there was the tribes were a significant force in the early 1800s, and the states and Congress were trying to move them out, and they were getting, the tribes were very skeptical of some of the promises they were getting, and so Congress allowed, as a sort of an inducement to get the tribes to move, that a tribe could elect to have, in addition to treaty promises, the land in fee simple. And that's what happened with the Creek. And in fact, the other side, Oklahoma, tried to say because this land was in fee simple, it somehow wasn't a reservation. And our response, which you saw in Justice Gorsuch's opinion, was that has it exactly backwards. The whole point of the fee patent and giving them the land in fee was to give the tribe additional protection in addition to the treaty promises. So, that kind of fee ownership was very important. In terms of takings, and I apologize if I have this wrong, but I believe there have been takings claims that were adjudicated by the court decades ago having to do with some of the takings of the land, and so I do think that the tribes. I believe the tribes have sought compensation and received But am I wrong on that?
They did. No, you're not wrong. No. That's completely correct. I don't know that would I don't know that the levels that they adjudicated it would hold up in modern day. To be fair, I just think, but
right.
But yes, there were like, and also like, as we discussed before, there were a lot of like things that happened in which like you would have ownership of things but lose rights to various, like the bundle of sticks, like you would lose rights to like transfer or like whatever else, and that was not compensated for by the federal government in any appreciable way. So like, but we don't need to get into that right now. We have a question. Sorry.
But can I just say one more thing that the last question asked? There definitely were, the Congress definitely breached part of the treaties, and they did eliminate the fee simple ownership. I mean, they transferred the ownership of the land to the settlers, and so there's no doubt that Congress did, in fact, repudiate many of the promises.
But that doesn't like transferring the fee simple to like did they transfer it to a trust or something? Like it's not like transferred to into a fee simple. Like I'm not.
No, they allotted it. They
allotted it. Okay, they assigned it. They assigned it.
Okay. Cheated out of it on an individual basis.
Okay.
Correct.
Okay. Sorry, I did not understand that. That makes a lot more sense.
So Jack Sullivan, you get the last question today.
Thanks, and I'm sorry if I accepted too early in terms of getting raptured in.
Oh, no. We brought you in because we never know when we're going to the next question. It's good to have somebody there, kind of basking in the sunlight and ready to ask a question at any time.
So jurisdiction in Indian country is a very complex deal, and I think one of the things that demonstrates that in this particular case is that Mr. McGirt's not an enrolled member of the Creek tribe, he's an enrolled member of the Seminole tribe, and what the Major Crimes Act says is so long as you're an Indian, you have to, and the crime occurs in Indian country, then you have to go to federal court, which has always struck me as being kind of an odd deal, but it demonstrates the kinds of complexity that you've alluded to with regard to the jurisdictional issues that arise from these things. The question I have, and looking through it, is whether there's anything new in this decision for people who practice in Indian country in terms of sorting out these jurisdictional issues. The only thing that seems to be new is just acknowledging the existence of this particular place as being Indian country, that even the concept that was relied upon and saying that this establishment has to be explicit and can't be inferred from all of this host of things that was referred to is not a new idea. So the question I have is there anything new as far as all these sort of the multiplicity of jurisdictional issues in Indian country?
So I would say the answer.
Question to end on.
Yeah, I would say the answer is no. That we certainly had argued that this was the continuation of an approach to treaty rights and reservation disestablishment that had been, settled certainly by the court in Parker. I do think that, doctrinally, in terms of reservations, the court had in prior cases put more emphasis on what happened to the land in the wake of, in the years following the congressional action. And in Parker, this case from 4 years ago, the court had really stepped back and said, we're focused on the text, not what happened. And certainly Justice Gorsuch's opinion made that crystal clear, that the court is saying, we're looking at the text, not what happened afterwards. And so I think that is confirming something that the court had already started to do. But in terms of the jurisdictional allocation, no, this is what has long been the rule in Indian country. There was no change. What the big change is the court is taking treaty promises embodied in text very seriously. And that's a critical thing for Indian country.
We are going to leave it there. Ian, thanks so much for joining us. This has been a super conversation and one that I really appreciate your doing.
It's my pleasure, Kate and Ben. Thanks for having me on.
Ian, Kate, you're brilliant. Please come back sometime soon, by the way.
I'd be happy to.
You're smart and great. I love this. I would love to do this conversation 8 times. Like, this is amazing.
All right. Well, hopefully the pandemic won't last long enough for me to come back too many times. But anytime you want, just give me an invite. I'm happy to chat.
Excited about it. So, Kate, who do we have for tomorrow?
I have either Kashmir Hill or Jillian Flopovic. We have to figure it out. I'm going to be on that tomorrow. That'll be my thing for tomorrow. But yeah, hopefully that. And
by the way, for everybody who listened to the Carrie Johnson episode, where Carrie and I were talking about our old executive editor, Tom Watson at Legal Times, and his penguin throwing game, Carrie and I have challenged the penguin beanbag, yes. We have challenged Tom Watson to come on in lieu of fun and defend the penguin toss game, and he has gamely agreed. So we will have a fun, and Carrie has agreed to come back.
I love her. She's so
part
great.
Of the inquisitorial panel about penguin tossing. So we will.
Maybe we should do a cornhole, and we should I'll send you, Ben, a cornhole, and I'll send Tom Watson a cornhole, and then there will be you have to have the penguin bean bags, and then Carrie will be the judge.
Yeah, exactly.
And we can live stream it.
To be fair, Tom spent a lot more time on throwing penguins than I did. I got hit by a lot of penguins.
That means nothing. This is a new game. That means nothing.
Right.
It's a new game.
So we will be back tomorrow, 22 hours and 55 minutes from now. And until then, Kate.
We don't have fun anymore. So in lieu of fun, I will have to say that I feel like this is a small moment of justice for Native peoples in America that has been really nice to enjoy. So thank you, Ian, for coming on.
All right,
Definitely.
my pleasure. All right,
see you tomorrow.
Take care. All right, bye-bye.
Bye, guys.